Long before watch brands fought for attention online, they fought each other in courtrooms, risking everything to protect a single name on a dial. And the battles they fought more than a century ago still shape the watch industry we know today. So let's step back into a forgotten chapter of horological history. In the golden age of American watchmaking, a name was more than a stamp on a dial. It was the heartbeat of business. It carried the weight of precision work, long hours at the bench, and promises made to customers who expected nothing less than accuracy. Protecting that name was not a matter of filling a form or sending an email. It meant waiting for rumors to arrive by letter, clipping suspicious advertisements from trade journals, or hearing from a traveling salesman that a competitor was selling something under your banner. Proof had to be touched, held, carried into court, a catalog page smudged with ink, a watch plate engraved with the wrong maker's name, an affidavit sworn in careful script. In the 1890s, this slow-moving machinery of brand defense roared to life in Waltham, Massachusetts. The Waltham Watch Company, founded in 1854, had built its reputation into a national standard. The name alone spoke of watches good enough to keep America's railroads on time. Then came word of trouble. The United States Watch Company, working out of the same city and steeped in the same industrial culture, was marketing watches under the simple label Waltham. It was enough to muddy the water for customers and dealers alike. Inside the gaslit offices of Waltham's attorneys, stacks of advertisements were spread across desks, with clerks comparing phrases, movements, and markings. Letters from confused buyers were read aloud, their tones swinging between disappointment and frustration. By early 1899, the case was ready. When the Massachusetts Supreme Judicial Court ruled that March that Waltham had acquired a secondary meaning tied to a single maker, the relief was palpable. The injunction was later upheld in federal court. Months of work, dozens of people's efforts, and an untold sum in legal costs had been spent, but the name was safe. Only 2 years later, another storied watchmaker would find itself in a similar fight. The Elgin National Watch Company, founded in 1864 in Elgin, Illinois, had become another pillar of American horology. When the Illinois Watch Case Company, also based in Elgin, began stamping Elgin on its products and even renamed itself the Elgin Watch Case Company in 1892, the challenge was direct and personal. The idea that customers might walk away thinking they'd bought an Elgin watch when only the case bore the name was intolerable to company leadership. They moved quickly, winning an initial injunction, but the Illinois firm refused to yield, and the case wound its way to the United States Supreme Court. On a cold January day in 1901, the verdict came down. Elgin was a geographic name, and no company could own it outright. For Elgin National, it was a gut punch. Years of cultivating an association between Elgin and fine watches swept away by the principle that a city's name belonged to all who worked there. Decades passed, and the landscape of American watchmaking shifted, but the risks to a name remained. In the early 1950s, Waltham found itself targeted again, not by a watch rival this time, but by the Star Pen Company. Their Waltham Pen Company nibs traded on the quiet prestige of the watchmaker's name. There was no database to flag the infringement. Perhaps the discovery came from a jeweler flipping through a supplier's catalog or a salesman spotting the pens in a shop window. The Federal Trade Commission took up the case, and in 1951 issued a cease and desist order. The decision came faster than Waltham's earlier court fight, but the principle was the same: protect the name, because without it, everything else could be taken too. From 1899 to 1951, these disputes form one long thread, a story of companies pouring months of effort, courtroom hours, and scarce resources into defending a handful of letters. They built their cases without instant communication, hunted down evidence across states, and argued before judges who had to weigh the worth of a name in human terms. Waltham's victories proved it could be done. Elgin's loss proved there were limits the law would not cross. More than a century later, the fight has moved online, but the stakes have not changed. The name is a promise, and once it slips from your hands, no court in the world can truly give it back.